Hello everybody, and welcome to looking at a breakdown of refusal to issue case law. And I thought I'd do the case law series. This is the second in the series because of how important case law is. It's an addition. It sort of clarifies, it fills the gaps in any loopholes that we might have in the current legislation that's out there. And case laws come directly from the upper tier tribunal. So Buckinghamshire CC versus SJ. So yeah, a child young person being able to achieve qualifications is irrelevant to a child young person needs if a child young person needs an EHCP. The only question the LA should be looking at is if the child young person needs an EHCP in order to access special educational provision. So it's an additional criteria that local authorities are trying to put on it when it comes to a child being able to achieve qualifications. It's not in law, it's not backed up by law, and this case law cements that and basically states that if a child can achieve qualifications or not, that's irrelevant. What we're looking at is if a child needs special education provision and needs an EHCP in order to have that special educational provision. What the child can achieve is irrelevant. Sometimes, children can achieve, they just need the special, all children can achieve, it's just having the right kind of support and provision in place to ensure they achieve. So Manchester CC versus JW. So when an LA and school lacks understanding of a special educational provision or fails to provide, then an EHCP is necessary. Parents do not need to evidence why special educational provision would not be in place at a school. They only need to evidence that an EHCP is necessary. So if a school in LA have failed in their duties to identify needs and provide provision, then it's not on the parents to provide or the evidence to prove this. All the parents need to do is prove that at this stage it's necessary for an EHCP, regardless of what the local authority of school have done, regardless of how much they've failed them, regardless if they've not provided no support. And even if the local authority and school are set going, well, they've not had support, that's not a reason. That's no reason to deny provision. And it's no reason to state that a child doesn't need an EHCP. And we do find that quite often where a school and the local authority has failed in their duty to provide special educational provision and identify a child's needs because they don't understand it. Quite often it comes down to a lack of understanding and a lack of expertise. However, that does not mean a child wouldn't need special educational provision in accordance with an EHCP. So Nottinghamshire CC versus SF. So the upper tier tribunal upheld the first tier tribunal's decision that it was necessary that an LA made an EHCP for a child. It determined that the word necessary does not have a fixed meaning and the judgment on it is to be made by the specialist tribunal. The comparison must be made with national mainstream standards, not local standards. So basically what it's saying is a local authority cannot say that they are not providing an EHCP for a child because they believe at the schools locally to them it would be ordinarily available provision, because a specialist tribunal decide on the word necessary, they decide on the judgment, and their comparisons are not going to be on the schools locally. Their comparisons on what nationally would be expected of a mainstream school. So when local authorities try and provide provisions or documents stating what they think ordinarily available provision is, what this is saying is the decisions made on what's expected nationally of autism of ordinarily available provision, not what is a local authority's definition of ordinarily available provision. Hertfordshire CC versus 1MC 2KC. So the upper tier tribunal dismissed a local authority's appeal that was not happy with the decision made by the first tier tribunal that EHCP was necessary. the upper tribunal considered the question of if it was necessary. So this is where we're looking at that word again. Necessary is a very ever-flowing terminology, and it changes, doesn't it, from one case to the next, and what one expectation to another. And what they're saying here is they agree with the first tier tribunal's decision that it was necessary for an EHCP and that the local authority should have done it. And they have looked at the decision, they've looked at the evidence provided from all parties, and they have dismissed the LA, saying that they agree still with the full first tier tribunal's decision on what is necessary, and that the local authority need to, because it's necessary. It's a bit like when we're talking about the others, it's that definition of necessary and what's termed necessary, and it sounds like, again, for example, when a local authority is saying, well, we have this mainstream school rule that can provide this ordinarily available provision, therefore we don't deem it necessarily for that child to need an EHCP. However, if that child was to move schools or move local authorities, etc., that wouldn't necessarily be the right statement, if you know what I mean, because it might be that that school doesn't provide that ordinarily available provision, or that local authority has a different version of what ordinary available provision is, which is why when we're considering what's necessary, it's got to be a national standard of what's ordinary available provision, not what each local authorities come up with in their policy and what they deem is ordinary available provision. Otherwise, how are we going to make decisions of first tier tribunal or upper tribunal, and how is it possible, and it's not possible for every single local authority to present their policies to first tier tribunal and say, this is our policy and this is what we work with. That's not how it works. The first tier tribunal and upper tribunal work with the law. They don't work with local policy, and local policy is just that, local policy. It doesn't trump anything that's said in law.